That's how Lynette Davies reacted when she learned the Department of Justice had opened the door to cracking down on cannabis businesses.
When I first read it, it's just like, it just makes your heart drop.
Lynette has owned CannaCare for more than a decade and remembers the days when federal raids sent her friends and colleagues to jail.
The first or the second raid in Sacramento is we had to keep literally a list of things in case you were arrested. You would have to do. Who's going to pick up your kids? Who's going to feed your animals? Who's going to call your patient base? Who's going to come out and hold a protest line?
Thursday's directive rolling back an Obama-era policy of largely leaving marijuana enforcement to state and local governments worries Lynette.
We have never, ever gotten into this industry with the intention of getting rich or high, ever. So I think that's a difference in what we came forward. Would that help me in court? Not one bit.
There's no defense.
Former federal defense attorney Mark Reichel says the Attorney General Jeff Sessions' new directive could be devastating for people in the cannabis business because in his experience, people charged with federal marijuana crimes only have 2 chances of avoiding conviction.
Number one is it marijuana? And number two is, did you possess or sell it? That's it. There's no third defense to it.
However, he says it's too early for business owners to panic. The fate of California's marijuana industry will largely depend on whether local U.S. attorneys will make enforcement a priority.
Definitely wait and see, although I imagine most of them are going to gamble and just keep going forward.
For those who do.
So if you've got a client in the marijuana business, what do you counsel them to do?
Number one, definitely follow California law to the letter of the law, number one. And number two, be prepared to answer and explain to the federal government why you shouldn't be prosecuted criminally.